the discussion was whether we should start from the basic definitions. And you could see from my previous slide that we didn't have the exact definition, what is the crime of aggression, what is the crime against peace. The International Military Tribunal Charter just mentioned that we want to prosecute those who are responsible for planning, preparation, initiation, or waging a war of aggression, but it doesn't define the war of aggression as such. When the question was raised towards main prosecutor Robert Jackson, why we don't have this definition, Jackson said we don't need it because it's obvious. Aggression is this what Germany did, so no further explanations are needed. But if you want to apply definition to all states and individuals in the world, we need to have a clear definition. And the discussion about this definition started in early 50s of the 20th century and lasted till 1974. And only then we could proceed with
Кримінальної установи пан Джексон заявив, що нам, власне, не потрібно
And this code was finally adopted in 1996, but with certain limitations. The crime of aggression was mentioned in this code, but for example, it was stressed that universal jurisdiction not necessarily should be applied to the crime of aggression, that obligation to extradite those who are guilty of international crimes not necessarily is applied to those who are guilty of the crime of aggression. And also there were doubts whether all the principles of individual responsibility should be applied to those who are guilty of the crime of aggression. So we could see already in 1996 that there is a problem that crime of aggression is a little bit or completely different from other crimes, and we need to think about special rules concerning this crime. In Rome, during the negotiations of the Rome Statute in 1998, states could not achieve the consensus. So that's why what they could agree was the safety valve, Article 5, Section 2, which just mentioned crime of aggression, but said we will prosecute crime of aggression when we finally agree on the definition of the crime of aggression, when we finally agree on the conditions of the exercise of the jurisdiction over crime of the aggression. And then the discussions were ongoing in the special group on the crime of aggression. Finally, in 2002, during the review conference in Kampala, the amendments concerning crime of aggression and concerning conditions of the exercise of the jurisdiction of the crime of aggression, they were adopted. But at the same time, states decided to delay the activation of the jurisdiction of the ICC over the crime of aggression. And so we had almost everything there, but states were not ready to prosecute crime of aggression. And still there were problems in what exactly situation crime of aggression could be prosecuted. The very first ratification of the amendments on the crime of aggression happened in 2012. It was Liechtenstein, the leader in the negotiations of the concerning crime of aggression. The 30th ratification, is so important because we had to achieve at least the level of 30 ratification that the amendments could enter into force, happened in 2016. In 2017, Assembly of States Parties of the Rome Statute finally decided to activate the jurisdiction of the ICC over the crime of aggression, but also clarified that this jurisdiction over the crime of aggression is extremely limited, and I will explain it in a moment. So decision on the activation took place in 2017, and jurisdiction was finally activated, could eventually be exercised from 2018. Today, we have only, or so far, 45 states parties which ratified amendments on the crime of aggression. The most recent ratification was of Niger. And we have 2 declarations lodged based on Article 15 bis. I will explain it in a moment. So you could see that the road to the prosecution of the crime of aggression, which could be applied to, in principle, any state which is willing to have this kind of jurisdiction, was a very long one, and in the ICC it could happen only in 2018. So what kind of problems we have, and that's why I would start with the jurisdiction problems, because these were the problems which we encountered, especially in the discussion on the situation in Ukraine in the recent times. Well, the problem is, which we can identify, is that the regime concerning the activation of the jurisdiction is completely different in comparison to the war crimes, crimes against humanity, or genocide, in case of the proceedings which are which starts from the initiative of the prosecutor or because of the state referral. Also, there is a specific role of the Security Council in those proceedings, which starts with the initiative of the prosecutor or of the state. And also there are some differences in the procedure at the pre-trial stage of the proceeding. So what is the problem? In 2017, in the decision on the activation, states emphasized that in case of state referral or proprio motu investigation, the court shall not exercise its jurisdiction regarding a crime of aggression when committed by a national or on the territory of a state party that has not ratified or accepted these amendments. What does it mean in practice? It means that the possibility of the ICC to prosecute crime of aggression is extremely narrow. Both states, the state which is responsible for the aggression, which is an aggressor, and the state which is a victim of the aggression, they need to be state parties to the Rome Statute, and it's not sufficient. Both states need to ratify amendments on the crime of aggression. Only then, and under also the condition that none of them would declare that they want to exclude jurisdiction of the ICC over the crime of aggression, then the ICC could prosecute aggression. You could wonder, okay, why, if somebody ratifies amendments on the crime of aggression, at the same time declares that it doesn't want to have this crime applied towards it? Well, it is possible because some states were interested in ratification of the amendments on the crime of aggression and to facilitate activation of the jurisdiction of the ICC, but not necessarily wanted to have this crime used against them, against aggression which took place on their territory or was performed by their nationals. However, I must say that all those states which decided for the ratification of amendments, they didn't decide to opt out from those amendments. So you see that there is no possibility to prosecute crime of aggression committed by a non-state party. It is not possible to prosecute crime of aggression committed against non-state party. But also, you cannot prosecute aggression even if you have a state party, but this state party didn't decide to ratify amendments. So extremely narrow jurisdiction, which is limited today to those 45 states which ratified amendments. Of course, there is a possibility that Security Council would refer the situation and then would trigger the jurisdiction of the ICC over the crime of aggression. But as you know, this is extremely difficult or almost impossible, having in mind the veto power of the P5 states, and especially their hostile approach, at least some of them, like US, Russia, China, towards the possibility to prosecute crime of aggression. Then I mentioned that there is a specific role of the Security Council. This was the main headache of the negotiators, how to arrange it that we have independent court, but at the same time, we recognize the role of the Security Council. And the idea was that, okay, firstly, we need to ask Security Council whether Security Council classify the situation as the aggression. And then we can proceed with the proceedings. Of course, it could be that Security Council doesn't take the decision because of the veto. And then we are safe because the prosecutor needs to wait only 6 months. After 6 months, if the prosecutor is convinced that this is the aggression, the prosecutor may ask for the authorization from the pre-trial division. And this is another difference, because usually if we have a pre-trial stage of the proceedings in the ICC, all those decisions at the pre-trial stage are taken by pre-trial chamber. But because crime of aggression was considered as so controversial and so, political backed, that's why state decided that pre-trial chamber, it's not enough. We need to ask the whole pre-trial division. So this is another difference which we see in comparison to the to other crimes. And maybe I didn't stress it enough, but why the crime of aggression is so different? I told you that we can prosecute only if both states are parties to the Rome Statute and both states ratified amendments on the crime of aggression. Whether, for example, in case of war crimes, it is sufficient that war crimes were committed on the territory of the state party or the state which recognized ICC jurisdiction, or were committed by a national of this kind of state. So the possibilities are much, much broader. And then we can go to the merit article, which explain us what is the crime of aggression and also imposes certain limitations. You could see that Article 8 bis adopted in Kampala mentioned that the crime of aggression means planning, preparation, initiation, or execution by a person in a position effectively to exercise control over or to direct the political or military action of a state, of an act of aggression, which by its character, gravity, and scale constitutes a manifest violation of the Charter of the United Nations. This definition refers also to the list of acts mentioned in the resolution of the General Assembly 3314. But please notice, they refer only to the list of the acts, not to the whole resolution. And that's why you have the controversy, because in the resolution, it was adopted that in principle, the state which uses as the first one the force should be considered as an aggressor. But this rule was not adopted here in Article 8 bis. So you cannot apply it immediately. What you can refer, it's just the list of those acts of aggression which are mentioned in the resolution. If we look at this provision, and now I would like to talk about this in detail with you, we need to focus on two different steps. Well, firstly, if we want to talk about responsibility for the crime of aggression, we need to assess whether aggression was committed by a state. First, you need to have aggression of the state, then you can decide whether you have crime of aggression committed by individuals. And what is aggression? You could say, oh, it's easy. It should be the easiest question, but it's not, because we only have the definition from the UN Charter and also from the resolution of the General Assembly. This is the use of armed force by a state against another state in contravention of with the Charter of the United Nations. But the problem is that the rules concerning use of force are blurred on purpose by states, and nothing is so obvious. Yeah, you can also see those acts of aggression to which the Article 8 bis refers, and you have here different like invasion, blockade, an attack by the armed forces of the state on the land, sea, or air forces, the use of armed forces which are already within the territory of another state, or, for example, allow to use your territory towards another state to commit aggression, or sending groups in order to commit aggression. I must say that in case of war between Russia and Ukraine, I could say that all the acts of aggression which are mentioned here were committed. We can find examples of all of them since 2014. But still, there would be doubts whether this was really aggression, having in mind different justifications used by Russia. And so if you want to prosecute aggression, you cannot just dismiss them easily, but you need to assess them. You need to check whether there is any grain of truth in those justifications. So, of course, you would have problem to receive any decision from the Security Council. You need to consider all the circumstances precluding wrongfulness. So, for example, the references to self-defense, self-determination, invitation on the request of the state, and humanitarian intervention. all those justifications were used in rhetorics almost in all kinds of armed conflicts, which we could observe in recent decades. The problem which you also have, because in the criminal proceedings, we have this presumption of innocence. And the problem which you would have is that the accused could undermine your assessment and say, no, I had completely different information. But the information concerning aggression, usually these are the evidence which are related with the security of the state. Usually these are the documents which are classified, and there is problem to have access to those documents. And then, for example, if we talk about aggression, usually the highest level people are involved in this decision. And you, for example, if you would like to call for a witness the sitting head of the state of third states, which are not party to the Rome Statute, you would have problem, because even if you have the obligation to cooperate with the ICC and surrender the accused, the problem is that it doesn't apply to the obligation of third states to send witnesses to the court. And also, you could see that in Article 8 bis, they are talking about acts of aggression, whether in Nuremberg this was war of aggression. And this can also cause certain doubts. Why? In the negotiations, states were saying we cannot prosecute any kind of minor acts of aggression, how awful it sounds. So that's why they adopted understandings according to which only the most serious and dangerous form of the illegal use of force should be prosecuted. I would also remind you that in Article 8 bis, they talk about these acts of aggression, which by its character, gravity, and scale constitutes a manifest violation of the Charter of the United Nations. If you have adjective as manifest, it can be interpreted very subjectively. And I've read many expertise concerning different kinds of use of force assessed. And for example, for many lawyers, 2003 aggression against Iraq was not so manifest violation of the Charter of the United Nations. So I'm not sure whether everyone would be convinced that the acts of aggression committed, for example, by Russia against Ukraine would be really considered as manifest violation of the Charter of the United Nations, especially if you refer to the proceedings in the International Court of Justice, and you would see how the picture of the legality of this invasion is on purpose blurred by Russian representatives. And also, we could say that this definition of aggression which we have is a little bit anachronical. Why? Anachronic. Why? Because it excludes non-international armed conflicts, because this must be use of armed force by one state against another state. And overwhelming majority of armed conflicts still in contemporary world, these are non-international armed conflicts, but these kind of conflicts are completely excluded from the definition of aggression. And as I told you, because Article 8 bis of the Rome Statute doesn't refer to the first use principle, that's why the other more subjective assessment could be introduced in the court's analysis. So let's now go to the second step. If we manage to agree that the aggression of the state was already committed, maybe we can discuss the crime of aggression of an individual person. And here we have certain problems. Well, first, whether we can prosecute individuals who were not involved in the planning of the whole aggression in which we have different acts of aggression, but those people were just responsible for singular acts of aggression, like, for example, blockade of the ports of the state, whether this would be really sufficient, having in mind the jurisprudence of the previous courts, which were focused more on the war of aggression. I also remind you that Nuremberg Tribunal didn't classify occupation of Austria and Czechoslovakia as as war of aggression, but they say, oh, these were rather acts of aggression, but not criminal ones as war of aggression. This was changed in subsequent Nuremberg trials, but still certain doubts would appear. And just think about, for example, 2014 occupation of Crimea, which took place without any fightings. Whether this would be really serious act of aggression, which would be considered manifestly illegal to be prosecuted in the ICC if the ICC has jurisdiction in this case. Then also the responsibility for the crime of aggression is extremely limited by the wording of Article 8 bis because of the leadership clause which was introduced there. I remind you, it says that we can prosecute only those people who are in a position effectively to exercise control over or to direct the political or military action of a state. Yeah, so the person who can exercise control or direct. From the one hand, I can say, okay, you don't need to have official position. What is sufficient is that you could be even officially civil person without official position, but if you take the decision concerning political and military action of the state, you can be prosecuted. But it's not so easy because for example, in Nuremberg, we rather had a standard of shaping, influencing the decisions of the state. Here, what we require that you need to have a person which controls and directs. This is much, much higher threshold, which means that some people would be excluded. So, for example, if you are a puppet state and you have a representative of the third state which put pressure on you to commit aggression, this would not be enough to prosecute this person who puts this huge pressure to be prosecuted for the crime of aggression. If you have members of corporations, yeah, we know that, for example, in Nuremberg subsequent trials, the representatives of a group or IG Farben were prosecuted for crime against peace. But based on those provisions of Article 8 bis of the Rome Statute, this would not be possible, having in mind that maybe they influence, maybe they shape policy of the state, but they do not control and they do not direct because they don't have tools to do it. Of course, as it is in all kinds of the proceedings concerning international crimes, we are talking only about the intentional crimes. Yeah, so we need to prove that the person had really intent and knowledge that triggers this use of force in particular circumstances, which decides that we have the aggression. And you could also see that stages which are prosecuted in the Rome Statute, these are planning, preparation, initiation, and execution. Whether in Nuremberg, this was waging. Yes, so execution could be also considered as much narrower than waging, because waging could last years, yeah, and this would be the continuation of the aggression. Whether this would be considered as still execution of this initial act of aggression. And Rome Statute didn't exclude the possibility to refer to different kinds of defenses, including order, yeah, order of the higher authorities. So this is also something which we need to take into account in the proceedings concerning crime of aggression. So what kind of problems we have with individual responsibility? As I told you, in the Rome Statute, the problem could be with very narrow leadership clause, which is much narrower in comparison to the Nuremberg standard, that there are some certain categories which are excluded because of this leadership clause from the potential jurisdiction of the ICC. And also, if we need to prosecute those who direct or control political and military actions of the state, usually this would be the highest authorities. So we would have heads of state, prime ministers, ministries of defense, and so on. Those people, they have immunities and privileges. And in the ICC, this doesn't shield them from the responsibility, but it could cause problems, and we could observe it in case of Bashir with extradition of those people when they are traveling to the third states. Fortunately, after Bashir affairs, some states like South Africa are much more cautious, and they do declare that they would arrest people against whom we have arrest warrants. We also have problem that without extradition of those who are guilty of the crime of aggression, should we have a trial in absentia? In the ICC, this is not possible. This was excluded by states. So you really need to arrest the person to start the proceedings. And what could be left is just the trial of scapegoats, which could be quite frustrating for the public opinion and undermine legitimacy of the court. You also need to remember that accused of the crime of aggression, they have right to exercise, to benefit from all fair trial guarantees, including presumption of innocence. And as I told you, the accused would start with undermining your assessment that aggression was committed. The accused could refer to the documents which are classified and which other states would deny to reveal to the court. The accused could refer to testimonies of people who would deny to come to The Hague and to testify. So there are different issues which could appear. And also, I've heard opinion, for example, of Kevin Heller, who said, okay, we have crime of aggression included in the ICC, and it's so limited that definitely it wouldn't be used. So it's good. It's good. Under this condition, it could work, that we will never use the jurisdiction over crime of aggression. And I do agree with him that in the ICC, it would be impossible unless we adopt additional amendments which would broaden the jurisdiction of the ICC. But even if there were proceedings concerning crime of aggression, we need to also think about the dangers to the ICC. And please do consider that the court should take into account whether the proceedings are in the interest of justice, and also the ICC needs to be extremely selective, having in mind the scarce resources which are at the disposal of the court. One of the problem which I could observe is that in Nuremberg, the prosecution of the crime against peace really shadowed other crimes. Yeah, so for example, for us now, Nuremberg the focus is on Holocaust, but it was not the case. Yeah, the focus was on crime against peace, and the danger could be that those atrocity crimes could be neglected. Also, because aggression, security, these are the political issues, the whole proceedings could be politicized, and no matter what kind of decision the court would take, the whole proceedings could be undermined, and the credibility of the court could also be undermined by one or another state. There is also a problem with complementarity, because many states, really many states, they do not have proper provisions concerning crime of aggression. Some of them, like for example, Germany, if they have the provision concerning crime of aggression, they just deal with the crime of aggression which was committed against Germany, but not, for example, against another states. So this is not full complementarity which we have, for example, in reference to other crimes which are covered by the jurisdiction of the ICC. And also, we know that there is a victim fund, the victim assistance in the ICC, but in case of the crime of aggression, it's very difficult to say who is a victim of aggression. Well, the victim of aggression is a state, but who is a victim of the crime of aggression? All people of the attacked state, or maybe also those people who were engaged in the use of armed force against their will, or were enlisted, and they had to fight with this war. Yeah, more and more we are talking about maybe violation of the right to life of those who were forced to join the army which conducts aggressive war. So definitely the prosecutor and the court needs to reflect on this, what is in the interest of the court, whether the engagement in the prosecution of the crime of aggression is really in the interest of the court. And you could see that I did mention many differences between the Rome Statute standards and Nuremberg standards. Yeah, that the Rome standards are narrower to some extent, sometimes we think that they broaden the scope because they talk about acts of aggression, not about war of aggression, but in practice, having in mind the additional thresholds which you need to meet, this jurisdiction of the ICC is much narrower in comparison to Nuremberg or Tokyo Tribunal. And these are important issues. Having in mind, for example, the current discussions about possibility to establish special tribunal for the crime of aggression in reference to the conflict between Russia and Ukraine, because maybe the standards which we have in the Rome Statute are not the best ones. And I did check the Central Eastern criminal codes, and what I could learn is that usually those states, including Ukraine, Belarus, Russia, so those states which are the most interested, they do refer to rather Nuremberg standard than this which we know from the Rome Statute. And having in mind all my doubts concerning prosecution of the crime of aggression, all those risks which are related with the prosecution of the crime of aggression, maybe now this is really good moment to seriously treat prosecution of the crime of aggression. Maybe this is also the moment to clearly say that we do not accept immunities for the people who are responsible for the crime of aggression. It was already said by many states during the Second World War. Maybe now it is worth repeating this. Maybe this is also the time to send strong signals to all those who are aiding and abetting in the commission of the crime of aggression, that all those involved could be also prosecuted for the crime of aggression. Think about all those who are, for example, helping in transfers of weapons and so on. And also, maybe this is also right moment to think how to avoid selectiveness of the prosecution of the crime of aggression and define what is for us the main value which we want to protect by international criminal proceedings. Because if we want to just protect people against atrocities, forget about crime of aggression. It's not worth to waste money on all those discussions. But if for us the value is the peace as such and the prevention of the war as such, maybe this is the time to think about the re-evaluation of the amendments on the crime of aggression, which we have in the Rome Statute. So I would stop now, and of course I would be happy to answer any questions if you have any.
Thank you, Patricia. That was very informative, but we are still left with the question, why? So why the jurisdiction of the ICC is so narrow, and why the states are not willing to prosecute the aggressors on their own forum, in their own jurisdiction, before their own courts? Because it seems to be a very old-fashioned attitude towards the crime of aggression. It seems that all the other states, other than the 45, which ratified the amendments to the Rome Statute, it seems that all the states, so the majority of the states, accept aggression. So they accept aggression as a means of conducting politics, as I remember correctly. So it's just politics, it's just international relations conducted by the means of the crime of aggression. And I remember I read your article on justified war and how the attitude changed towards, throughout ages, towards the aggression. So in the beginning, aggression and aggressive war were justified in the eyes of the international society. And it seems that 500 years later, still the majority of states would rather not ratify the amendments, just in case they would feel like waging an aggressive war, maybe. So could you answer this question, please? Thank you.
Well, we need to remember that when the negotiations of the Rome Statute started, this was a very good moment and unique moment to adopt the Rome Statute, but still the memory about the Cold War and the accusations of two blocs were quite vivid. And we know that there is no state in the world which would start the war having said, yes, we commit aggression because it is in our interest. All the times the states would claim that they are acting in self-defense. They are acting because they want to protect other people. And we observe it exactly in every case of the aggression. So many states, those big powers which were so agitated to intervene in different areas of the world, they were afraid that crime of aggression could be used against them. So, for example, United States, they did explain, we intervene in different states, but we are doing this to protect human rights, and we don't want to have the situation where, because of our goodwill, we are now prosecuted for the crime of aggression. So that's why US from the very beginning were very against the introduction of the crime of aggression. And also China and Russia were quite hesitating and reluctant to limit the competences of the Security Council, because in the Security Council, they have veto power. They don't have the control power over the ICC. So they didn't know in which direction could go the prosecution of the crime of aggression, and whether this prosecution could undermine decisions of the Security Council or even be an obstacle to achieve the peace. There were arguments which were saying prosecution of the crime of aggression would stiffen the position of the other side, because if we accuse the person for the crime of aggression, then the person would fight till the death, because know that the prosecution of the crime of aggression is somewhere there. But I would say that this, so in principle, majority of states were just afraid that ICC would be very willing to prosecute crime of aggression, and this could be used against them. I think that now, after 2 decades of the works of the ICC, they see how difficult it is to trigger jurisdiction of the ICC, even in the most serious crimes, that this is really very long process, very difficult ones. And they also, when you talk about the abstract situations, you could wonder whether it is politicized or not. But when you have a clear example of aggression, it's really incomprehensible for the public opinion why we still don't have tools. As you said, after a few centuries, we still don't have effective tools to prosecute those who are guilty of the crime of aggression. And this frustration, these discussions about the activation of the ICC in the case of the Russian or Russian-Ukrainian conflict, to maybe establish new tribunal, which is also frustrating because we need to spend additional money to create additional institutions. This triggered the will to adopt those amendments which are supposed to be discussed in November this year. So according to the propositions, the jurisdiction of the ICC over the crime of aggression would be the same as in case of other crimes which are covered by the jurisdiction of the ICC. So coming back to your question, whether it's all about politics, of course, because if we talk about international criminal justice, this is also kind of politics where always such values like justice, truth, peace would be used by both sides of the dispute.
Thank you, Patricia. Yes, I see. Yes, that's somehow I reject your answer, because politics where people die, it's not politics, it's murder on big scale. It's just not a matter of name, it's a matter of the principle. And now we have 2 questions. We have a question from Professor Basiler, who raised his hand. And are we able to give him the floor? Can we?
Yes, actually, I have already made Professor Basiler the panelist. I think that he should be already able to speak.
Okay, so
I believe yes.
First, we let Professor Basiler ask the question, and then we deal with the question on the chat.
Yes, can you hear me?
Yes.
Okay. So the question is regard to the situation is going on in the International Court of Justice, I read that the Ukraine is making the assertion that the Genocide Convention does not give the right of a country to come in and prevent genocide, which to me would seem like a very strange statement on the part of Ukraine to make. Now, I haven't looked at the actual statement. This was just a reporting by a media source. Can you comment on that? That seemed like a very unusual position to take for Ukraine.
Oh, I think that because I did observe those oral hearings in the court and the statements made by both Ukraine and Russia, and I would say that Ukraine's position is, because they, as you know, they could not start the proceeding in the ICJ just accusing the violation of the use of force by Russia, because then ICJ would not have the jurisdiction. They had to rely on the Convention on Prevention and Prosecution of the Crime of Genocide, and their claim was that that Russia used the genocide pretext to start invasion, while genocide was not committed in Eastern Europe. And this was the Russian argument by saying, okay, but if there was genocide, we should have a right of the humanitarian intervention. Yeah, so this was the issue, this paradox which you are saying. This was the argument made by Russia, saying to that Ukraine, sorry, if we had some allegations, we could react in this way. Look at the intervention of NATO in Serbia in 1999. Yeah, but I wouldn't say that Ukraine was really arguing that you don't have right to intervene to prevent a genocide. They just denied that any genocide for which Ukraine is responsible was committed in Eastern Ukraine. And on purpose, I did mention the genocide for which Ukraine is responsible, because this was also one of the arguments of the Russian agent, who was saying, no. In the initial submissions, you were saying that no genocide at all was committed in Eastern Ukraine. Now you are changing your submission and you are saying that there was no genocide for which Ukrainian state is responsible. So you see that there are now what we observe, these are looking for the gaps in the argumentation of the other side to undermine the whole proceedings and to stop this proceeding at this very preliminary stage. This is how I understand this whole discussion.
Thank you.
And I can also answer to those questions on the chat, which I see. The first question is, isn't there a danger in viewing the crime of aggression as the supreme international crime? Yes, I fully agree. I think that there is a huge danger on focusing only on the crime of aggression and to apply the standards which were used in Nuremberg. I think that like crime against humanity, war crimes or genocide are as serious crimes as crime of aggression. And we know that those crimes could be committed even without aggression. And I think that we should avoid the situation in which we will put all the resources to prosecute crime of aggression, having in mind how difficult it is, and at the same time we would neglect those other international crimes. But I do believe that this doesn't happen, that states are collecting evidence of all international crimes which are committed in Ukraine. And you are asking about this impossibility to prosecute crimes against humanity committed before the war. And this is also a very interesting issue, especially in the context of Central Eastern Europe, because Central Eastern European states, they did claim that what happened with Jewish population in Germany before the World War II, this was crime against humanity. And this was just big powers like US or UK, which opposed the idea to prosecute those crimes as crimes against humanity. And they were afraid that at that time, this was just against the rule lex retro non agit, that this would, that we didn't have clear rules on this, and they did oppose this proposal. It was coming from Czech and from Poland to also consider those crimes. So with anonymous attendee, I fully agree with you that we cannot stick to this description of the crime of aggression as supreme crime. Maybe it's important crime, but other atrocity crimes are also very important and worth investigating. And Ivan Gisem also asked me, okay, so how bring Putin and his associates to justice using existing mechanism of international law? So in case of other crimes like war crimes, genocide, crimes against humanity, we already have the possibility because we have ICC. Yeah, and ICC already issued 2 arrest warrants. We know that they are also prepared other arrest warrants by the ICC, which will be announced very soon. So in case of other crimes, this is not a problem. In case of the crime of aggression, there is a problem because, as I told you, ICC doesn't have jurisdiction and there is no possibility that Security Council would refer the situation to the ICC. So that's why there are discussions about the establishment of this special tribunal, and also the proposition, which was, I think, much supported by Germany, to have at least internationalized hybrid tribunal created together with Ukrainian system of justice. And to this proposition, Ukraine is opposed. And honestly speaking, I think that it doesn't matter if we call it hybrid, special. The most important is the legitimacy of this court. And that's why Ukraine rightly fights for the support from the General Assembly to establish international tribunal. Because if you would have at least this resolution of the General Assembly, this would give a huge legitimacy to this kind of court. And as we know from the jurisprudence of the International Court of Justice, international courts, they do not have to respect privileges and immunities. And this is the whole problem which we need to deal with. Because Poland, Ukraine, they do have jurisdiction over crime of aggression. They could prosecute crime of aggression. But the problem is that they would have to respond to the question, what about immunity of Vladimir Putin? In my opinion, if the works on the International Tribunal for the prosecution of the crime of aggression would not work, still I would try with national jurisdiction. And also this would be the attempt to clearly say we do not respect immunity in case of the accusation of the crime of aggression. Maybe this is the moment to clearly say it. Yeah, and I know that some of the states also in the works of the International Law Commission also emphasized this possibility that now states need to clearly say whether you are willing to accept the situation of impunity, or maybe we would agree now that in cases where you have a clear statement on aggression, because General Assembly already said that this was aggression, in that situation we could prosecute those guilty in national courts.
It seems that we don't have more questions on the chat. So if you,
I see one more hand raised. So I will also give the rights of panelists to Dariusz Siewicki. Dariusz, I have promoted you. Yes, you are a panelist now, so you can speak. You can also use video if you want. Dariusz, you are muted. Now we can hear you. Yes, we can hear you.
Fine. Oh, now you can even see me, I think. So thank you very much for giving me the floor. I appreciate what the professor said about the risk that the focusing on the crime of aggression and prosecution of the crime of aggression can actually deflect the attention from prosecuting crimes which are much easier to deal with, the crimes of crimes against humanity and crimes on war crimes. And it reminds me the intellectual dispute between Herr Lauterpacht and Raphael Lemkin, where Herr Lauterpacht argued that actually criminalizing genocide would put aside the crimes which are not less atrocious and which carry on the same intellectual criminal content. So maybe we could keep in mind that there is already a system that can deal with criminal activities and at hand, and it's not that necessary. It's not that important to pursue just the crime of aggression, because this could just dilute the problem, dilute the attention of the international community. Thank you very much for giving me the floor.
At the same time, I must say that if you refer to this dispute between Lauterpacht and Lemkin, we could see that both concepts are useful, yeah, that we can refer to them and we can use them for good purposes. I think with the crime of aggression, we could also find a way to deal with it, but we need to be very honest, frank, and not be selective, because one of the arguments against prosecution of the crime of aggression committed against Ukraine is that, oh, this is, why we are so selective? You didn't prosecute US for interventions. You didn't prosecute France for intervention in Libya, which abused the resolution of the Security Council. So why now you are bothering about the aggression against Ukraine? And I fully understand these critics, especially expressed by some African states, yeah. But at the same time, I think that in case of the aggression against Ukraine, there are some specific circumstances. The circumstances are that in this part of the Europe, it's clear that for many decades, we did accept that we need to prosecute crime of aggression. And if you would like to check history of any kind of prosecution of the crime of aggression, overwhelming majority of them did happen here, in Poland, in Hungary, in Finland, in Russia, in Soviet Union at that time. Some of them, these were show trials, for sure. But some of them, they were really genuine attempts to understand what did happen and to attribute the responsibility. And I think that's why I'm a little bit concerned to just think about the Rome Statute standards, because in case of Nuremberg standards and the proceedings which took part in national courts, we had many proceedings concerning the occupation authorities. So those people whose job was to separate the particular territory from the state and prepare the accession of this territory to the aggressor. The same we can observe now in Eastern Ukraine, that you have the people who are responsible to undermine the links between Eastern Ukraine and Central Ukraine. Yeah, so I think that the discussion about the scope of the prosecution needs to take into account all those difficulties, but at the same time, do not forget about all the other crimes. Do not forget that behind those all other crimes are also people who were killed, tortured, and sometimes it would be much easier to prosecute them and attribute the responsibility and convince not only our part of the world, but convince the whole world that it's worth prosecuting them. Mm-hmm. So, for example, I think that many would argue that Putin should not be prosecuted for the crime of aggression. But if you explain that he's responsible for the transfer of children, for stealing those children, majority would say, yeah, I get it. This is really a crime. On this, we can agree.
Mm-hmm. Actually, here is the question from anonymous participant related to this, what you have just mentioned, so these attempts to take control over the specific territory. Here, the Republic of South Ossetia is mentioned in the question. So how do you think could be South Ossetia considered a subject of the crime of aggression? And yes, how this subject will be considered as a child of Russian Federation, as part of Georgia, or as independent subject of crime?
This is really tricky because South Ossetia or other territories where you had conflicts at the beginning of the 90s, these are sometimes called frozen conflicts, and with unclear status. So this is unclear legal status. So that's why if I refer to this definition concerning the definition of the crime of aggression in the Rome Statute, you remember that you would need this manifest violation of the UN Charter. I'm afraid that in case of South Ossetia, this would not be so clear and manifest, having in mind the complicated history. And that's why I do understand, for example, Ukrainian concerns that they don't want to have another frozen conflict in this area. But these kind of situations like South Ossetia, we have many in the post-Soviet territory. Please tell us what Ukraine needs to do in order to organize such a hybrid tribunal. In this case, we need usually with hybrid tribunals, it's a little bit complicated because you have different kinds of hybrid tribunals. So this would have to be negotiated between Ukraine and here you need to decide whether this would be UN, the best one option, having in mind legitimacy, or this would be the regional organization, and then which one? Council of Europe, from which Russia was withdrawn or was excluded, or maybe European Union, considered as political organization. Here the discussions are also quite difficult. But of course, if you would have this international agreement, you could, in this agreement, you could really decide what kind of crimes, national, international, you could decide on what terms, who would be involved in the judging of those crimes. So it's up to the negotiations between Ukraine and interested organization. But I do believe that in the interest of Ukraine, and Ukraine does everything to convince that UN should back this kind of agreement.
Thank you, Patricia. We don't have any more questions written on the questions and answers chat box, but I would like to use my position and ask you another question because it bothers me. What is the role of the Security Council? And don't we need a change in the model of the Security Council itself? Because it has an immense, very serious role as stipulated by the Rome Statute. So it is responsible for stating that a crime of aggression, an act of aggression, actually was committed. And how was this provision created when it was clear that the members of the Security Council, the permanent members, would never be punished or prosecuted for the crime of aggression? Maybe there is also a need not only to change the attitude towards immunities, but also the attitude towards the Security Council. Of course, that's an academic question, but how do you see the role of the Security Council in the whole procedure of prosecution of the crime of aggression?
Well, I wouldn't like to have Security Council role at all in the procedure concerning crime of aggression, but I did understand that this was something which we could not avoid to have in the Rome Statute. And as far as I know, in the propositions of amendments concerning crime of aggression, there is no proposition to exclude the role of the Security Council as such. Because for many states, Security Council, this is a symbol, maybe the bad one, but of the United Nations, and this is also the tribute to the organ which it has this primary responsibility for securing peace. And this is the issue. If we agree that the value which is protected by the crime of aggression is peace, so then immediately we need to jump to the conclusion, who is responsible for keeping the peace? Security Council. And this was the issue which was raised. Okay, so why should we ignore Security Council in this discussion? Should we make obstacles for the Security Council? Maybe Security Council should have a word on the situation. But at the same time, as I explained to you, when Security Council says, yes, this was aggression, please proceed, still ICC is independent, and still ICC could say, no, based on the evidence which was submitted, this was not aggression according to the tribunal. And I see even the greater danger in this, because that's why I think that maybe Security Council should not be involved at all in the proceedings before the ICC, because the fact that when the ICC says there was aggression, there was or there is no aggression, and it would contradict the statements of the Security Council, I think it undermines the position of the Security Council, and at the same time, this opposition undermines the credibility of the court. Yeah, so that's why I think maybe it's better that those bodies are completely separated. And I do see the change in the attitude of many states. Like, for example, for Central Eastern Europe, it was obvious that Security Council needs to have its rights secured. But this was, you know, in 1998, early 2000. Yeah. Then many states say, okay, Security Council could stay there. But one more thing, maybe we should also have General Assembly to be able to refer the situation. Like, for example, now Security Council is unable to take the decision on the war in Ukraine, but General Assembly was willing and adopted several resolutions concerning this conflict. If General Assembly has competence to refer the situation to the ICC, ICC would already have the jurisdiction in this case. So one of the propositions which is on the table is not to exclude Security Council from the Rome Statute, but to add General Assembly as the body which is much more democratic, which is much more open to the discussions with all states in the world. Maybe not all, because we do remember that, for example, some states, they do not have chance to get to the UN. And I have in mind Palestine, which was already mentioned in my presentation as one of the states which already ratified the amendments on the crime of aggression. And we are not surprised why.
Thank you. I'm in favor. There are also two more questions on the chat.
Do you think that deportation of Ukrainian children constitute a genocide according to the Geneva Convention, or rather a crime of aggression? No, I think that deportation of Ukrainian children is not an act of aggression, as we understand it today. It's definitely, it could be classified as a war crime. It could be classified, having in mind the scale, as crime against humanity. I am unable to say whether this is also the genocidal act, because to say that this is genocide, we would have to prove this genocidal intent, that these deportations are to exterminate Ukrainian group as such. But I would not exclude this classification. I think that there were many disturbing statements by the highest Russian authorities, in which we could learn that they deny the right to existence of Ukrainian nation as separate nation. And I think that based on this, we could build case on alleged aggression committed by Russia against Ukraine. But so I see such a possibility, but I wouldn't say that I'm sure of this kind of classification. Why Ukraine didn't ratify the Rome Statute for this time? I think that there is no explanation to this for the moment. At first, there were problems with the constitution of Ukraine, but the proper changes were introduced, and so there was a possibility to ratify the Rome Statute, and it could be done. Yeah, it could be done. You did mention me what is the problem also with the hybrid tribunal. Ukraine claims that with the hybrid tribunal there is a problem because it would be against its constitution, and they cannot change their constitution because of the state of war. With the ratification of the Rome Statute, there is no such a problem. They did change their constitution before, and they could ratify the Rome Statute. But please do take into account that also if you ratify the Rome Statute, you are also expected to pay, to contribute to the expenses of the court. And one of the arguments which is used is that Ukraine is not ready to pay any additional contributions. But I think that this argument is quite weak, especially that the Assembly of States parties many states are delayed with their payments, and always Assembly of States parties can say that still you keep your right to vote even if you don't pay the fees.
Okay, thank you, Patricia. There are no more questions. Is there anybody who would like to
maybe Just a short comment from my side. You know, there is also this tendency visible to see the crime of genocide as a kind of a supreme international crime. And there are like, maybe it's not proper to say, somehow like disappointment when lawyers kind of question the possibility of using the crime of genocide. But what I think is worth underlying that, you know, that this crime of genocide may be a result of building up the case, you know, and in the end, there may be grounds to build such an indictment using the crime of genocide. But first, Ukraine or generally any country needs to concentrate on these other war crimes, collecting evidence to prove all other international crimes that are being unfortunately committed in Ukraine.
I do agree with you. We need to remember that from the point of criminal responsibility, the fact that I would say that deportation of children are war crimes or are crimes against humanity doesn't mean that these are less serious or less worth investigating crimes. This is for sure. So from the point of criminal responsibility, I would even suggest that it's better to not go with the genocide classification because it's much more difficult to be proven in the court in comparison to crime against humanity or war crimes. Also, please notice, if you look at all the proceedings which we had in the ICC, over 90% of them, these are the proceedings concerning crimes against humanity. Yeah, we had just one accusation for genocide. It's not without reason. It's just very difficult to be proven, this special intent. So that's why it's a very nice idea, but quite useless, you know, in the criminal courts, in usual context. But if you say that this attempt to classify the situation in Ukraine as genocidal acts, I see the relevance of this in one situation, and it was already mentioned by Michael Basiler. Without this classification, Ukraine could not start the case in the International Court of Justice. And please do remember that this case in the ICJ, it has two aspects. One is to check whether Russia could use the argument concerning the alleged genocide to start the war against Ukraine, but the other question, the other question which was asked by the Ukraine was whether Russia commits genocidal acts in current armed conflict. And in this aspect, for example, the possibility of classification of deportation of children could be investigated. Yeah, because this is this part which helps us to proceed in the ICJ. Without the convention on the genocide applied to this case, it would be impossible to start a case in the ICJ, unfortunately.
Yeah, thank you very much for this comment. I'm just looking, I do not see more questions in the chat. I do not see any hands raised. So I believe that we can slowly close up our meeting. Haniu, I will give the floor to you then.
Thank you, Patricia. Please, I encourage you to ask more questions. We have a translator that could translate from Ukrainian, because you have at your disposal the best expert in the area of the crime of aggression. I said Professor Grzebyk is the best specialist in Poland, but it's also worldwide.
Yeah, but maybe it's a good sign because our listeners are more convinced about the value of prosecution of crimes like war crimes and crimes against humanity, and they do not want to waste too much effort on prosecution of the crime of aggression. Maybe it's a good signal, you know, having in mind all the arguments which we used in our discussion.
Yeah. But having also in mind that the crime of aggression is the mother of all the international crimes, we cannot forget about it, and we cannot be silent about it, even if in practice there is still so many obstacles. So
the obstacles which we can overcome with goodwill, we can overcome all the obstacles. But the problem is, as you did mention, Hania, before, that the politics plays here a huge role.
Let's not surrender. Let's fight.
But you know, generally during this last year, same as the full-scale aggression against Ukraine, we have been observing so many changes also in the politics. I remember when Ukraine started to promote this idea of this special tribunal for the crime of aggression. At the very beginning, there were not much supporters of this idea, and this is changing. So, and also Professor also mentioned that there is this like increasing awareness, which may be transformed into the political will to finish with this impunity for the crime of aggression. So I think that this what is happening, what we observing, and thanks to this, maybe it's not a proper word, but the war in Ukraine make us changing some presumptions that we used to believe. We have the question, I believe, here because I see that seven. Yes.
So just to also comment what you have said, that's why I did put this suggestion in my presentation that maybe it's a really good moment to rethink about the responsibility of crime of aggression, to really seriously think about those risks, about those dangers related with the prosecution, but at the same time there is a need, there is a will on behalf of the public opinion to deal with those responsibility for the crime of aggression, and we cannot neglect it if we want to respond to this need of the public opinion. And what is optimistic, I did investigate how, for example, what was the road to Nuremberg Tribunal, and I must say that this was not the idea of big powers. Yeah, this was the pressure, the stubbornness, the irritating way of reminding of crimes, which was done by smaller states like Poland, like Czechoslovakia, like Belgium. They did put pressure. If you look at the statements which were made, this was 1939, 1940, 1941, and then 1942, where those states were made statements that we need to prosecute Germans, and big powers were just observant. They were just listening. And then finally it clicked, and big powers also engaged in the discussion about the prosecution of this crime. So it's 2023. 1 year passed, more than 1 year passed from this full-scale invasion, as you said. Yeah, it's on the one hand, if you take into account the victims of the war, it's already 1.5 years. But from the perspective of the changes in international law, it's just 1.5 years. And I would link this with the answer to the question whether Ukrainians should intensify their efforts to bring Russians to justice. I think that Ukrainians, they do a lot to bring Russians to the justice, and I really admire how innovative they are in using different tools, different procedures. This mentioned by us, the proceedings in the ICJ, is also very innovative, and having in mind the unprecedented scale of intervention of third states in this proceedings, it shows that we really see the changes in the world. We really see the changes in international law. So Ukrainians, they are doing already a lot, and they are. And what I could say, I think that this is not Ukrainians who should intensify their efforts. I think the world needs to notice finally those efforts, and I think we should forget about debates about the justice for Ukraine without Ukrainians, without the people from this part of Europe which is affected. It cannot be the discussion which is, in US or in UK without people who are directly interested. We learned our lesson. We did adopt proper laws in our criminal codes. We did prosecute crime of aggression in the past. We are prepared. We are prepared. No other region in the world is better prepared than us to prosecute crime of aggression. So I think Ukrainians need to just have this stable level of efforts to bring Russians to justice, and still we need to remind the whole world that their voice needs to be heard and respond.
Wow. it was a very strong, I dare to say, political statement, Professor. It sounded this, but I'm really grateful that you have also underlined this really sophisticated work that is being done by lawyers from Ukraine to change the international law, and they are really effective in doing this. So this is something that for us lawyers from other countries is really impressive. So full respect to the strong team of Ukrainian lawyers doing this amazing job.
I think this is the perfect statement to close the discussion. There is so many things problems we could discuss, but it's getting late. The questions are not coming, not appearing. So it seems that everybody has solved the problems and has had all the questions answered. And with the strong statements and with the hope that the attitude will change and that we don't need to abandon all hope, and that the crime of aggression will be prosecuted effectively someday, not so far away from now. So thank you, Professor Grzebek. Thank you. We have one more question.
Oh, I was supposed to comment. This is Martin Jadot, and yeah, I do agree that in the genocide, because Martin just reminded us that in the Genocide Convention, we have one of the act which is called transfer of children from a group to another one. So that's why at the first sight, we could say, yes, we have an act which is identified in the Genocide Convention as possible genocide, yeah? But please do remember that apart from the acts which are mentioned in this convention, we need to still fulfill the conditions which are in the chapeau of the genocide crime. So we need to prove this intention, this special intention to exterminate, to eliminate the group as a whole. And I think, as I told you, it is possible. It is possible, but we just need to collect very convincing evidence, having in mind how cautious courts were in the past concerning any allegations of genocide.
Yeah, so we have managed to answer more questions that we predicted. Thank you very much, Hania. Thank you very much, Professor Grzebek. I'm also very grateful for Natalia and Simona who are translating our meeting into Ukrainian. The webinar that was organized by the Project Sunflowers in cooperation with EU project Prawo Justice. I wish you all a calm evening, calm night, especially in Ukraine, and hope to see you soon on, for sure, next seminar that we will be organizing dedicated to this topic. Thank you again.
Thank you, Anna. Thank you, Patricia.